Proceed.
Good evening, Your Honor, ladies and gentlemen of the jury, co-counsel, opposing counsel. My name is Marilyn Harrison, and again, I'm representing the plaintiff, Shirley Hart, who is here representing the estate of her late mother, Marion Hart. Ladies and gentlemen of the jury, there is no smoking gun, but there is smoke. All of the dreams of Shirley and Marion Hart went up in smoke on 31 July 2023. We seek justice for the mother who someday hoped to be a grandmother, who someday hoped to be a mother-in-law, who someday hoped to live to the ripe old age of 80. We seek justice for the daughter who someday hoped to share her future children, who someday hoped to share the joys of matrimony, who someday hoped to share in home ownership. I don't know about you, but you never stop needing your mother. How many times do you call and ask, how much sugar goes in this? You may be asking yourself, why? Why did this lighter explode? Why did this person die? Why is this company liable? This lighter exploded because of its owner's desire to save $2. Ms. Hart died because she was the unfortunate victim of this intentional design flaw and inadequate warning. This company is liable because they owed her a duty of care. In my opening statement, I told you the theme of this case is profit over safety. Any commercial supplier owes a duty of reasonable care. An inadequate warning is not legally sufficient. Or if there is an adequate warning, but it's not easily accessible by the average user. This product was not made, labeled, and tested in accordance with regulatory standards because there were no regulatory standards. There was an unreasonable risk, and it was foreseeable. And that risk cost the plaintiff her life. The elements. Let me talk to you for a quick second about preponderance of the evidence. The plaintiff has to prove that it's more likely than not that Acme had a design defect and that defect caused the wrongful death of Marion Hart. That means I only have to prove 50.0001% that this was their fault. 4 elements: the design defect of the product. We showed you through expert testimony the actual lighter, the instructions, causation. We showed you the paramedic report, and we showed you the autopsy report. Foreseeable. We showed you through Acme, their own witnesses, their own instructions, their own expert, and their inadequate warning. Lastly, damages. We showed you through economic damages through our witness, Shirley Hart, as well as non-economic damages. Our expert testified that this was an unreasonably dangerous product and that they had the option to remedy it. They had the option to make it safer. Their own instructions here show the steps, the 5 steps that you had to take to make this lighter work. This wasn't something that you could just take out the box and use. The paramedic report, the highlighted portion says This person's body was badly burned. The autopsy report shows her death was the direct result of smoke inhalation caused by that last word that's highlighted, exposure to an explosion. That was the causation. Foreseeable use. Mr. Mercer, who bragged so loudly about his baby, the magic light, said, "We wanted to make sure everyone using this lighter would read the instructions and know how to use it properly and safely. That lighter can be a lot of fun, but it has to be used correctly." And so you ask yourself, was it foreseeable that this lighter could have been misused? If it was foreseeable, then they had a duty to warn adequately. That warning on that label was inadequate. That warning in those instructions, if the instructions were in there, did not warn of an explosion possibility. And who's to say that was in there? That is a disputed fact. Last but not least, damages. Shirley Hart got a bill in the mail for $7,500 to bury her mom. She got a bill in the mail for $2,500 in medical costs. In addition to that, she had to take off work for 2 weeks. Non-economic damages. We are seeking that you award this family compensatory damages, personal injury, property damage, economic loss, loss of consortium. Now that's a fancy word for loss of companionship, loss of the relationship that she had with her mother, something that's irreplaceable. Shirley has already lost her father. Her mother was a widow. Now she has no parents, no siblings. Pain and suffering. Pain and suffering of Marion Hart. Marion Hart was on a fixed income because she was a widow. I charge you that the value of Marion's life is not only comprised of an economic component, but of the intangible value of life as well. You, in evaluating her pain and suffering, may consider the following factors: fear, fright, shock of impact, actual pain and suffering, and mental anguish. Did you find our witnesses credible? Mr. Berg, the one who showed up on the scene and tried to save Marion's life. Did he have a good memory? Did he impress upon you as being right? Did his testimony differ from the testimony of anyone else? Mr. Wilson, our expert, Ms. Hart, the autopsy report by the medical examiner. The measure of damages to Marion's death would be the full value of her life. The value is to be determined by your enlightened conscience. Marion was 51 years old. That's part one in valuing her life. She had a life expectancy of 81 years. That's part two, 31 years that she was robbed of. How long would Marion have lived? She would have lived, if she had lived her full life expectancy, an additional 31 years. Does ACME think that they got lucky, that they're responsible for someone's death, but they're not going to be held accountable? What if Marion did not die? Let's imagine for a second. If Marion Hart had not passed away from her injuries, but in fact was a bedridden paraplegic for the rest of her life, for the next 30 years, she would have had millions of dollars to keep her alive. She would have needed millions. Yet because she was killed, the value of her life is worth more than any medical treatment. Would you pay $1 million to stay alive for an additional year? All the medical treatment in the world is not worth a year of your life. When a fighter pilot is hit while flying their plane, the military tells them, always eject from the plane. Do not go down with the plane because your life is worth more than the plane. Marion lived and suffered for 33 minutes. The worst 33 minutes of her entire life. I ask you, if it were me, if it were you, what's 33 minutes worth of pain and suffering? $33 million? You may feel more comfortable at 5 or 6 million. The choice is up to you, but we need your help. We need you to hold Acme responsible, make them accountable. They've been dodging this family for 2 years. Hold them liable. Thank you, ladies and gentlemen.